giving you a full class period to do the exam, and another class period to go over it. We'll see if it works. I don't know, but I want to at least give you that opportunity. All right. Any questions before I get started? Yeah, Allison, go ahead.
For the actual exam, I wasn't sure if you ever said if it's going to be like one question with 5 parts or 2 questions.
Yeah, no, I did say it. I'll say it again. It's going to be at the midterm. It'll be one question, 1,000 words. We have 2 hours. So it's a trade-off. You have more time, same amount of words, but fewer questions. It will probably be harder, right? So I'm going to compensate because there's only one question to make the one question tougher. If that makes sense. Yeah. You have to make trade-offs. I have 90-something students this semester, and we have tight deadlines for grading for everyone. And it's a 2-hour class. I don't know why it's a 3-hour exam, but we'll do 2 hours. Okay. All right. So let me begin. I'll put the screen share on for the first and only time this semester. Where is it? Okay. All right. So again, to Allison's question a moment ago, your exam will be just one part, 1,000 words, the full 2 hours to do it. Please don't write beyond 1,000 words. I'll stop reading. In exam software, there's a word count feature. It's not obvious. There's a feature for character count, which counts the number of letters. Next to it, there's a little document icon, a little page icon. If you click that, it'll pop up with a word count. If you don't understand what I just said, that's fine, but do a sample exam through ExamSoft before the semester is over. Don't walk in trying to figure it out during the pressure of an exam. You're going to get nervous and mess up, and it won't be good. So you'll have 1,000 words for the entire exam. Open book. That means printed. I would love to let you use your tablets and save paper, but unfortunately, there's no way to do it to avoid cheating. If you have devices, it just makes it too easy to cheat, to have a group text and whatever else. Now, cheating is very stupid on my exam because these are very hard fact patterns. It's very unlikely the person you're cheating with actually knows the answer either. And if you're wasting time communicating, you're going to run out of time. Also, keep in mind that if you're cheating, you're going to probably tip me off. I read every essay very carefully. And if I see things that are very similar, I get suspicious. A couple years ago, we had one exam where 2 students had very similar papers. Not altogether, but there were parts that were very similar, and I suspected cheating. And what turned out to happen was that the students had pre-wrote answers. They had basically written canned answers in their outline, which they then copy and pasted into the exam. Maybe not the best strategy, but there's nothing unethical about it. As long as it was done in advance, I can't stop it. But my point is, if there's similarities, I'll know. I don't activate the stalking software where it monitors if you look this way and look that way and look that way. And it's not because I don't trust it. In fact, the AI is quite good. The AI is better than human proctors. Human proctors suck. They don't catch anything and they fall asleep. They're reading a book. The AI is very good. I trust it actually quite well. But for my exam, it doesn't matter because it's open book. You're supposed to be looking around and looking at your notebook and leave your outline. So it would create too many false positives, so I just don't activate it. But you'll have in other classes, so just be careful. All right. So again, this is part 1, 50%, but your question will only have one part and it'll be 100%. Same five subparts, but just be one part for 100%. Instructions. This sounds very stupid and obvious, but please read the damn instructions. Read them, please. It contains information that you need. I'm not giving it there just to be fun. It's really useful information. The most useful information is the year you're in. This was a feature of my common law exams and property since beginning. I think it's too easy to test you on the current state of the law because the law has changed quite a bit. I can't test you on older doctrine if I say what's the law that exists today. So I will either pick a present year, the year is 2021, or it's some year in the past. In the event the Supreme Court decides some case the next week before your exam, don't worry about it. It's not fair game. I'm not going to test you on it. Someone always asks me that. I mean, it's a live issue. It could happen. I remember when I was in law school, I had an admin law exam, And the morning of my exam, there was a huge case, which of course I read that day. And I talked on the exam. Professor like, "What you do?" I'm like, "I read it." Right. But I'm not expecting you to do that. That goes above and beyond. So, if the court decides Fulton, tomorrow, I wouldn't make that fair game. We just assume Fulton hadn't been decided. Okay. That might be the only case that could affect, because we Fulton and maybe one or two others. All right. The year is 1864. The nation divided during the bloody Civil War. Congress has enacted 4 laws, which President Lincoln signed into law. The Attorney General is considering prosecutions. These are criminal statutes. And you have to write a memo addressing these 5 issues. Okay, so the first issue. By the way, if you notice, the exam is very short. It's barely 2 pages. The fact patterns are not long, but that means you have to really think carefully. Every word I pick is chosen very deliberately. There aren't like wasted words. Blake, it might have said 3 hours on wherever you're looking. Someone messaged me, but it's going to be 2 hours. I'm going to make sure that's clear on the when I spent the exam. They haven't actually asked me yet, which is fun because they should ask me, but it's going to be 3 hours, 2 hours. Okay. So the question begins. Horace Greeley, who is a publisher of the New York Tribune, writes an editorial. Actually was a very prominent figure in Horace Greeley. So these exams are based on fact to agree. You probably don't even care, but I make them actually close to fact. He charges that President Lincoln did not have the authority to wage a civil war. As many of you probably know, Lincoln never issued a declaration of war. As a result, Greeley argued people should resist the draft. Now, I'm not asking whether Lincoln had the power to prosecute the war. That would be a common law question. Here, the Attorney General is considering whether to indict Greeley for violating House Bill Number 1. That law provides, it shall be a felony to impede the operation of the laws of the United States by writing, printing, uttering, or publishing any false, scandalous, or malicious writings against the government of the United States. And the question, make sure you understand the question, is does this prosecution, or would this prosecution violate House Bill Number 1? I'm sorry, would the prosecution for violating House Bill Number 1 run afoul of the Free Speech Clause? Again, I'm not asking whether the statute is constitutional in its face. This is what you might call an as-applied challenge, right? In other words, if the government charges Greeley with violating the statute, would it be a First Amendment violation? Of course, this first question is premised on the Sedition Act of 1798, which happened, about 7 years earlier. I copied the text of the bill almost verbatim. So if you check up the Sedition Act, your notes, it's almost this verbatim. There's also some similarities to a case that hasn't happened yet, which is Debs. If you remember, the socialists urged people to resist the draft because he said the draft was unconstitutional, that Congress didn't have the power to compel people to register for the draft, and therefore you should resist it. So, there are lots of things you could talk about here. We have Madison in the Virginia Resolution. I'm sorry, we have Jefferson with the Kentucky Resolution, right? You might even think about, did this speech have some sort of a tendency to frustrate the government operation? We're far away from Debs, but that's a sort of doctrine that I think would be useful to discuss. But if you just stuck to Madison and Jefferson, the Kentucky Resolutions, then I think you're in good shape. But you should not be citing cases that happened after 64. Okay, let me stop here. Questions? Questions on? Yep. Let's see. Go ahead. Yeah, Macy, go ahead.
So we can't discuss cases that haven't happened yet, obviously, but can we talk about ideas? Like I talked about how encouraging citizens to resist the draft would create a danger to the country and would be a national security risk. That's okay?
Yeah. Just be careful not to talk about the case, but absolutely, that's fair game. Really, because I think the sort of arguments in Debs from the majority opinion, at least, were based on what the Federalists argued in the Sedition Act. They made those arguments 2 years earlier. Okay, Lauren, go ahead.
For this question, would it have been necessary to talk about the fact that this was not, in fact, lawful? Or because if we did say that Lincoln did not, in fact, have the ability to wage war, then is it an unprotected category of speech anyways?
So if you noticed, I didn't even put the word libelous in the statute.
Okay.
I'm pretty sure, hold on, I wrote this question 2 years ago. I'm pretty sure the actual statute had the word libelous in there. I think I took it out deliberately in anticipation of that question. Let me just double check.
Now that I'm reading it, it does not say that.
No, okay, then I didn't.
No.
Well, then.
No, I mean, your question does not, and you probably did it specifically for that reason. Is what
There was actually, no, I was close. There was another section of the Sedition Act that mentioned libel. It wasn't this section. But
Okay.
So I don't see the word libel in there. I mean, I think it's a creative answer. What you're doing is good. The word false is in there, I think, which may sort of get at what you're asking, Lauren. So
Yeah.
if the statement was in fact false that Greeley was making, then perhaps you could charge it, say it was libelous. And it was libelous would be outside the scope of the First Amendment. I think that the question of whether someone has legal authority is very much an opinion question. It's hard to say that's a false statement because people disagree. And even people in Lincoln's own party, this is not being up my scope of your class, but that would seem to be more of an opinion, a legal opinion, than saying, President Lincoln is 5 feet tall and he's actually 6 feet tall, right?
Okay.
So I don't think that would be a false statement to give your legal opinion, because legal opinions usually are exempt from libel laws. So that goes a little bit deeper, but it doesn't quite work. But I like what you're thinking.
Okay. Thank you.
Yeah, and I knew there was libel in the statute. I just forgot where it was. I hadn't looked at this in 2 years. Alexandria, go ahead.
Hi, since we are in 1864 for the purposes of this exam, do you want us to mention if the court hasn't addressed this issue yet?
I wouldn't bother. I mean, I think you're kind of wasting time. I mean, yeah, I know they haven't. That's why I'm asking this question. But good thought. Because really, every question, the court hasn't addressed this yet. Every one of these 4 questions will be first impression. Because in the 1860s, there were not many free speech cases at the Supreme Court. And let me actually answer your question a little bit differently. This is not a case before the Supreme Court, and I regret what I just said. You're advising the Attorney General, so it's not like this is a case of first impression. There's no case. They're asking whether to bring the prosecution in the first place, and that framing actually alters the question because there's one of discretion, right? If this is a case of first impression, maybe you err on the side of safety and don't bring it. Right, you don't bring this sort of prosecution when you don't have authority to rely on or precedent. So that might be, that actually might cut the other way.
Okay, thank you.
Yep, my pleasure. All right, who else? Blake, go ahead.
I guess kind of on that same note, I was looking at it as if the AG does prosecute it and it was to move through it. And in mine, I kind of talked to the AG about fact that it could be a case of first impression and whether or not we want to push that kind of idea through.
Fair point. Yeah, I like that. Yeah, because it says he's considering whether to indict him. And then you might tell the Attorney General, this has never been decided before. We have the Sedition Act, which was not a very popular thing. You might err on the side of safety and not bring the charge.
And what's your opinion on this? Because in doing that, I thought about how cases that were decided later, I thought about how they were decided and used that to think about how the Supreme Court could sway one way or another and whether or not the AG wanted to push our rights and law.
Yeah, I think now you're trending into shaky ground. I would not go quite that far, but I think it's fair to say, if you're considering this prosecution, we don't have any authority on it, we should proceed with caution. I think that might be a more prudent way to write this one.
Okay.
Yeah, good question.
It's definitely different than your property exams and trying to.
No, you're absolutely right. It's a different world. I feel like I'm a different professor in these 2 classes. I teach them back to back, so it's like I have to flip a switch or something during lunchtime. All right, thanks, Blake. All right, what other questions you have? Anyone else on number 1? This is your shot. Going once. Going twice. All right, I'll move on. Number 2. All right, number 2. This is about a case called Ex Parte Merryman. Did any of you study this in con law? I wasn't able to teach it this past year because of COVID, unfortunately. I had to cut it. We just didn't have enough time. But Merryman was about a Confederate prisoner who was held by the Union Army at a base in Maryland. So this is actually loosely based on something that happened, but not really. John Merryman, who lives in Maryland, invites Confederate sympathizers to his home. During these meetings, he displays a Confederate flag. And he does so to build support for the Confederate States of America and to oppose what he sees as Lincoln's illegal war, sensing a pattern here. Merryman's efforts are often successful. Many of the people who visited Merryman's home ultimately joined the Confederate Army. The Attorney General is considering whether to indict Merryman for violating House Bill number 2, which provides, it shall be a felony to use a Confederate flag as a sign, symbol, or emblem of opposition to the government of the United States. Oh, I have a typo there. That's embarrassing. I'm sorry. I just noticed that. I read these things so many times I miss typos. In opposition to the government of the United States government. Okay, well, you know what I meant. I apologize in advance for the typo. That's very embarrassing. Question, would prosecuting Merryman for violating House Bill number 2 violate the free speech clause of the First Amendment? So here we're talking about what you might call symbolic speech. That phrase didn't exist yet, but that's what we would call it today. Where they're not prosecuting for words, a spoken word, even the printed word, but for using a symbol or a sign or a flag. So this is based on Stromberg, which was the case with the red flag or the Soviet flag, which was a symbol to promote communism, which is sort of the same idea here. You're promoting the Confederate government. This also implicates sort of the O'Brien-Johnson-RV line of cases where is burning a flag, for example, protected by the Constitution. Now, these cases are all out of here, but I think you need to start from very basic principles, which is why this is a good question, right? Is the First Amendment restricted to only the spoken word and the printed word? Or does it extend beyond the spoken and printed word, right? Would the First Amendment extend to, there were no TV cameras, but like maybe a political cartoon, right? Or perhaps some sort of theatrical performance that was critical of the government. You have to get sort of creative with these old questions to try to reason the same way we would reason in class. Also ask, why are they punishing this particular type of speech? And it might be what we call a viewpoint discrimination. But still, would this form of viewpoint discrimination be permissible because you actually have a hostile enemy, right, trying to subvert the government? And this goes back to the Sedition Act, right? Can you punish speech that's trying to injure the government? Or do we just say that we're in the middle of the war, right? And in the times of war, the laws fall silent, and we just have to sort of defer to the government and let the executive branch do what they wish. Surprisingly, a lot of students didn't talk about the flag. They just talked about recruiting. But I think the flag was central. It wasn't prosecuting for the words. It was for this flag. And there are many different ways you can take. You have to think carefully of how to answer this based on what I call first principles, right? Just what exactly does it mean to have a symbol? What does the First Amendment concern? And that lets you bring a lot of different themes. Okay. All right. Questions. All right. I see I have in the queue, Jessica. Go ahead. I think you're on mute, Jessica. There you go.
I'm muted and unmuted. I was curious when we're talking, I pulled out Stromberg as the case, but you wouldn't mention Stromberg because it's after 1864. You would just say, and when you talk about whether or not it would incite violence, like the same sort of reasoning that came in that.
Right. It's in other words, why? The first question you have to address is, why is a flag even speech? Right.
Mm-hmm.
First Amendment says no law abridging the freedom of speech. Your very first point is the flag is speech, or maybe the flag's not speech. And if it is speech, is this a type of speech that can be suppressed? Because the Sedition Act was never held invalid by any court.
And for that, you would use the reasoning from Stromberg.
You could, yeah.
You could. Okay.
Miss Alexandra, go ahead.
Are you opposed to using like words such as could, this could happen, or this is?
I would really discourage it. People get in trouble doing it all the time. Don't say, well, this could happen and that could happen. Well, no, that's you're trying to fight the question. You're trying to defeat the premise of the question. So I would avoid that if you could. Okay, Michael.
Did Justice Holmes come up with the marketplace of ideas, or is that idea older than his subsequent opinions?
Yeah, he didn't make it up, but I don't know if I can trace exactly what year it began, and I wouldn't try to do that in exam. Say, well, was it around the 1860s? I don't think it was. It was probably the later part of the 1800s, but I wouldn't try to get that creative. But Holmes did make everything up. He was very well read, and he read a lot of things, so he probably got from different places.
Okay, thank you.
Yeah, but it's good. I see what you're thinking, but it's a good question. What else, number 2? Going once? Going twice? Okay, I can move on. All righty. Number 3. All right. This concerns the Emancipation Proclamation, which you had me for common law we studied. I don't know if Rocky did it, but we spent some time on it. The Emancipation Proclamation from 1863 freed the slaves in rebel territories. Most people don't know this. It did not free slaves in northern territories. There was slavery in the north. Oh, yes, there was. Maryland, Delaware, Kentucky, a number of Union states maintained slavery throughout the war and even afterwards. People don't know that part. Congress enacted House Bill 3. It provides the Department of the Treasury shall collect a tax of $100,000 for each slave held in servitude. And the failure to pay this tax will be a felony. Okay? So go back to our friend John Merryman. Merryman owns several slaves. He belongs to the Southern Baptist Church. The next part's actually accurate. The reason why we have a Southern Baptist Church is slavery, right? The Southern Baptist fractured from the Baptists because of slavery. And the Southern Baptist Church, this is accurate, not anymore, but it was for many years. The Southern Baptist Church adopted the view that God intended the races to be separate and that the Bible required the institution of slavery. And if you want to read about that, there's a long list of things you can read, but I just gave you a little snippet there. So I'm setting up a free exercise case. Merryman objects to House Bill number 3. He argues that imposing such a fine on owning slaves would violate the free exercise of religion. He's basically saying you're taxing my religious exercise. The same way if you put a tax on a communion wafer or sacramental wine, right? Or imagine you put a tax on peyote, right? Whatever your religious sacrament is. And he refuses to pay the tax. In the modern era, you have people who oppose war, who say, I don't want to pay Social Security taxes, right? Or I don't want to pay Social Security taxes that goes to the government that funds war, right? So even to this day, you have people who are seeking exemptions from taxes based on religious belief. So I was trying to get at that line of cases. And the Attorney General is considering whether to indict Merryman for violating House Bill number 3. And the question is, would prosecuting Merryman for violating House Bill 3 violate the Free Exercise Clause? Do not discuss whether Congress has enumerated power to enact House Bill 3. I think the statute's unconstitutional. It's not a direct tax. It's not an excise tax. I don't think the statute should be constitutional in any event, but let's just go with it. All right, so this is our religion question, right? We have a lot of stuff in religion that's not cases. So one of the starting points you have is Madison and the Memorial Remonstrance. And you might remember that Madison wrote that Virginia's proposed tax to fund house of worship violated the Free Exercise Clause. This statute flipped the issue. The tax wasn't imposed on non-believers. It was imposed on a person's free exercise of religion. But it didn't burden the belief. It burdened conduct. Conduct, right? The conduct of actually owning a person who was enslaved. does the free exercise of religion protect just belief, just thoughts and prayers, or actual conduct? This is this question which we never seem to leave. Reynolds was a polygamy case, which was decided, about 15 years later, so it's not fair game to cite. But the idea of does the First Amendment protect thoughts and prayers, or also conduct? And really, I think to this day, a lot of you have been emailing me in office hours, Josh, what's the deal with Smith and Lukumi and Sherb? I was like, shit, I don't know. Right? I mean, this year, I really don't know. Maybe the Fulton case will tell us any day now, but I don't know. Oh, and by the way, I was all beating up the Supreme Court. They took a gun case. They granted review in a gun case on Freddie Rolls. Like, see, Blackman, you were so. I'm a little skeptical because they finagled it a bit. Maybe talk later about it if we have time. But they actually took a gun case. So my case book will have it, not for the next edition, but the next edition, maybe 2026 or so. Something like that. All right. So we have Reynolds, right? What is the rule? Is it just conduct? Now, I think at this point, credibly, a student could argue either way because we don't have Reynolds yet. But I think if you went with the Reynolds rule, or maybe the Reynolds rap, if you will, you're on safe ground. What about the fact that tax is so high? I mean, even today, $100,000 is a very large amount of money. You don't need too much about inflation, but that's a lot of money. Is that making it a serious burden on religion? Maybe like a $1 tax would be okay, but in other words, let's just say that there was a general tax on wine, and people who bought sacramental wine for the church pay a sales tax, right? No big deal. But this is not a tax designed to raise revenue. It's designed as a tax to punish activity. And does that change the free exercise analysis? That you're trying to punish this specific religion? Is this actually more of targeting, right? We don't have Lukumi, but if the government's targeting just one religion, the Southern Baptist, this is a big religion. The entire South was Southern Baptist, or at least most of them were. But by the way, there were Jewish slaveholders, there were Catholic slaveholders. It wasn't just the Baptists; they were across the board. It's actually a fascinating history of how religions sort of warped to accommodate slavery, and religions changed and shifted. There were schisms where basically doctrine was rewritten to justify slavery. It's just a fascinating history that I think to this day affects modern day views of religion. I think there's just this view that religion is just this way to just justify whatever bigotry, and that's bleeding over to today. And some of the gay rights issues. This issue is old as time. All right, don't talk about Obamacare. I have difficulty not doing it, but we don't want Obamacare talk here. Almost done, Montana. Just another second. Okay, I'm done. That's fine. Okay, Montana, go ahead. Then Gavin.
So in addition to talking about Reynolds that they could punish the conduct if it violated a law, would you also say it's a generally applicable law, so it's not targeting this specific religion?
Right.
So they're not actually burdening the free exercise.
Well, is it generally applicable? I mean, I don't think you have enough facts and evidence to really make that judgment, but this seems to be very clearly directed at the what do you call it? At the Southern Baptists. Yeah. I mean, I don't know that this is generally applicable, but I think you could argue that it is. Does that answer your question?
Yes. Thank you.
Okay. Yeah, Gavin, go ahead.
Yeah, so I know we don't, because it's 1863, we don't have much reference, but I do know that, Thomas Jefferson wrote that letter in 1800.
That's right.
And I know that's regarding mainly like the Establishment Clause, but I was wondering if you thought that would have relevance in this as well.
Yeah, I think the Jefferson letter would also have fair game, and it might actually cut in the opposite direction. If there's supposed to be this separation between church and state, maybe that suggests that the state should leave the Baptists alone and not start taxing their religion. I mean, I think you can incredibly argue it both ways. It's ironic in this case. Madison would suggest that you perhaps can't tax him. Maybe Jefferson says you can't tax him as well. So a strict separations approach may have different outcomes. It's a good thought. Good question. Who else do you have at number 2? Someone writes in the chat, Learned Hand told Holmes about the marketplace of ideas. That's actually right. Very good. So I think Holmes got it from Learned Hand. By the way, you know what Learned Hand, his first name was not Learned. Learned was his middle name. His first name was Billings. Billings. Can you imagine your name is Billings, you go by Learned? A little bit arrogant. Probably Holmes didn't put him in the Supreme Court. He was also too old. Right, I mean, not Holmes, Roosevelt. Roosevelt thought of putting Learned Hand in the Supreme Court, but he was like in his 70s. They put, what was it, Wiley Rutledge instead, we've never even heard of. Guys who go by their middle name. What's that? I don't know.
I go by.
Oh yeah, that's you. Yeah, come on, but Reed is not Learned. Whatever. I mean, Thank you, Sienna. Thanks, Reed. Okay, you guys are funny. Okay, what else? Number 2. Alrighty, let's do number 3. No, we did number 3. Okay, let's do number 4 then. Actually, making pretty good time. All right, now we have our gun case. I was going to ask a Second Amendment question. All right, recently, this is true, by the way. Federal troops marched the streets of Baltimore on their way south to protect Washington, D.C. This actually happened. Baltimore was a hotbed of Confederate sympathizers. It was a very dangerous place. And there was a riot, and they resisted their passage. And then federal troops started shooting at the Marylanders. This is a very precarious spot for Lincoln, because if Maryland fell to the south, so think about it, you had the District of Columbia, Virginia to the south, Maryland to the north, right? If Maryland falls to Confederates, DC's gone because you can't protect it. It's covered on both sides. So Maryland was an essential foothold to the Civil War. A riot began. Many Baltimore residents were injured, and several were killed. In response, John Merryman formed a group known as the Baltimore Militia. Ooh, militia, right? Their goal, to protect the citizens of Baltimore from federal troops. This is a hard question. Members of the group would patrol the streets armed with their Colt handguns. So again, it's handguns, which was the weapon Heller said was quintessential. This firearm model was introduced several years earlier, and I actually had to check that. I think it was right around the same time. I have fudged the years a bit, but the Colt was more or less in that time frame. The Maryland government had no involvement in the organization or the regulation of this group. So Congress enacts House Bill number 4, and it provides, it shall be a felony to keep and bear arms when not in service of a state militia. This is one of the best questions I've ever written. Like, this was such a good question in the Second Amendment. Like, there's so many things to go on here. Oh, you're seeing the memo. I'm sorry. I had the wrong screen sharing. I apologize. Thank you, whoever said that in the chat. I think I know how to do this after a semester. No. Okay, now you're looking at it. All right. Well, all right, I already read the question, so that's the question, right? So that's your question, right? So there are a number of things to think about here. I think this is a really hard question. I took some care in writing it. So first off, of course, we have Heller, right? 2008, which held the Second Amendment protects the right to keep and bear arms. You don't have to worry about incorporation because this is a federal law, right? So don't worry about McDonald, don't worry about incorporation. The 14th Amendment didn't exist yet, so you don't have to worry about incorporation. That's not important. We have to make sense of Heller, right? I think there's a couple questions to think about. First, what exactly is the right protected by Heller? If Heller only concerns the right to keep and bear arms when you're serving a militia, the statute is constitutional, right? This statute basically resembles Justice Stevens' interpretation of the Second Amendment, right? This case resembles Stevens' interpretation of the Second Amendment. But what is a militia? Right? Who is the militia? The Maryland government had no role in this militia, but can the militia be a group of private citizens who are protecting the Baltimoreans from federal troops. Right? Wasn't the Second Amendment protected to prevent people from being disarmed by the feds? Were the militias fighting the British organized by the state, or were they just a group of people who were trying to keep their neighbors safe from federal oppression? So they're really hard questions, and you can go any which way in these. Where does the Second Amendment apply? Does it only mean you can have a gun in the home or on the streets? What about a handgun? I tell you, this is a fairly novel invention. There were no handguns at the time of the framing of the Second Amendment. Does the Second Amendment protect this novel technology? There were no handguns. I'm telling you this. This is a hard question, and students went many different ways with it. And maybe next year we'll know for sure. Does the Second Amendment apply outside the home, or is it limited to just carrying a gun from your bathroom to your living room? I don't know. Why? You should have the gun in your bathroom, but I suppose you could. Kitchen with the living room, fine. Okay. Questions on number 4. All right, I see Chrissa, then I see Macy, and then I see Lauren.
So just as a little bit of feedback, recently made me think now and not still 1864. So just by starting it off with recently, I got a little bit confused.
Oh my God, if in the year 2019 there are federal troops in Baltimore, we're in trouble.
Well, you don't know. Well, with the rest of your history, who knows what's happened in the last 20 years?
I'm talking about the Civil War. I mean, I don't think that's a reasonable reading. I mean, I appreciate the comment, but I think you should presume we're stuck in the frame of 1864. Don't. I get what you're saying, but I don't think that's the best reading.
Yeah. So then anyway, so the way that I took this was thinking about whether it was like too broad or too restrictive. So for example, like when it talks about service of the state militia, it's like, well, does that then mean that it's so narrow that the only people that would own a gun would be the ones who are active military, and then even when they weren't active, then they couldn't own a gun? And how restrictive is that? So is that like a fair kind of reading?
Yeah, and I think that's a good criticism of the Stevens opinion, right? Does that only mean you can have the gun when you're in the militia? Can you keep it in your gun home for storage, or only when you're actually serving? And that's actually one of the wrinkles of Stevens' opinion he sort of glosses over. Good thought. Yeah, if we're having federal troops in Baltimore, although maybe there are now, but we're in trouble. All right, Macy, go ahead.
Do you think we could have talked about whether or not the Second Amendment is an individual right or a collective right, assuming that they're not a militia because the state isn't involved?
Yes.
Still have a right because it's an individual right versus a collective?
Yeah, and specifically, though, it's whether or not it's an individual right or a collective right is tricky because arguably this is a militia, right? And that gets the question of what a militia is. There's also the issue of what does it mean to have individual right if you're using it to serve the militia? They're not asserting a general right of self-defense. So the individual collective right one doesn't answer this question cleanly. It's got to be a little more broad. Lauren, go ahead.
Sorry, so the way I started this question was interpreting what the Second Amendment actually means.
Good.
To me, based on my reading. So I started with originalism, and I guess my question is, should we even mention the word originalism? Because I talked about public meaning versus intent, but I guess if we're based in the year of 1864.
Originalism, maybe the word is new, but the concept is not. And looking to what the framers understood or intended as old as time. John Marshall did it all the time. If you read any John Marshall decision, he talks about what did the framers intend. So there's nothing novel about originalism. The label itself maybe is not used then, but I think the concept would be fair game.
Okay, so if I use the concept of looking to as a public meeting, that would have been okay.
Yeah, sure. Genevieve, is your hand up? I see your mic's off mute. I don't know if that means it was deliberate. Okay. Mic's back on mute. Okay, good. Blake, go ahead.
Even taking all these things into consideration, we can still go back to the call of the question as to whether or not to indict Merryman, looking at everything facially, because regardless of if they thought they were in a state militia protecting people, if this is a federal indictment and the government doesn't recognize this group of people as a militia, then facially they're not following House Bill number 4, right?
I think so, yeah.
Or it's at least a fair argument to pose.
Yep. Okay. What else? Macy, go ahead. It's your hands up again.
Okay, I have another question. I'm sorry.
Please, that's fine.
When answering these questions, are you okay with us kind of like going through an analysis of, this might be a potential challenge, but it could be defeated this way or this way. And even if the court ended up finding this, you could still argue this and that, and kind of like giving multiple.
I would read the question. This is Blake's comment from a moment ago. It says, should they bring this charge? And if you think there are some reasons why not, do that. But don't go down every rabbit hole. Just try to answer the question as clean as you can.
Okay.
There's always an infinite number of rabbit holes you can go down. Okay. Anything else on number 3? I'm sorry, number 4? We're almost done, guys. Oh, we'll actually finish on time, I think. All righty. Number 5 is what I call the policy question. Oh, and I was time to tell the Cuomo story. Good. I didn't forget. No, he never groped me, but it's sorry, that was bad. Governor Cuomo's gotten in trouble recently. If you haven't seen the news, it's not good. Okay. President Lincoln tells the Attorney General that he's conflicted about prosecuting Greeley and Merryman. The president recognizes that House Bills 1 and 2 infringe on a deep-rooted right of free speech. Yet Lincoln understands better than anybody else how fragile the union is. The president fears that if he does not take decisive actions, the republic may not survive. Please discuss the relationship between the freedom of speech and the preservation of national security. All right. So, I mean, look, this question is so open-ended. There are a lot of different directions you take this in. Right? You should probably start with the Sedition Act. Adams thought it was essential to protect national security. Jefferson did not. Does Lincoln agree with Jefferson or Adams? Probably he'd go with Adams. When you're in office, it's a lot harder. When you're outside of office, as the opposition, it's a lot easier. This is not about the courts. He's considering whether to allow these sort of prosecutions. You can think about the issues with World War I, perhaps with World War II as well. We talked about some of the issues involving fighting socialism in the United States. We talked about prosecuting, Klan rallies. We've talked about flag burnings. We've talked about, issues that sort of strike at the core of what people disagree about. So much. I don't give very precise model answers to this last one because I think there's just so many directions you can go in. Questions on this last one, number 5, the policy question. Nothing? Okay, Macy, go ahead.
Nobody else wants to do, so I will.
That's fair.
Is it on these type of questions where it's like open-ended, just kind of like, what are your thoughts more or less? Is it necessary to discuss specific, would it be necessary to discuss the Sedition Act and the Kentucky and Virginia Resolution? Because I just kind of look at it more generally.
No. You need to bring in authority, whether it's a case or some statute or something. I'm not just asking what's your opinion. You have to make a decision based on law. Lincoln would demand no less. He was an attorney. I mean, not you have to know this, but if you're the attorney general, you can't tell the president, yeah, this is a good idea because it feels good, right? You got to have something to go on. If there's some authority you think is wrong, then say it's wrong. I think Sedition Act was unconstitutional. You should not emulate that. You should not copy this. President Jefferson pardoned all the people who were convicted under this, right? It's viewed as this awful thing. We should not be the next Sedition Act. Fair game, but you have to at least discuss it. What else? All right. Any questions in general, things on your mind? Nothing? Okay, Samiha and then Lauren.
I know that for our con law exam, there was a cutoff as to when we could stop asking.
Yeah, thank you for reminding me. Okay. Let me look at my calendar. Just give me a second. What's the date for your exam, everybody? It's a Monday, right? Okay. Sunday's Mother's Day. Don't forget, everyone. Sunday's Mother's Day, the May 9th. Don't remember Mom. I already ordered my flowers. I'm good. Let's just say May 7th, the Friday at 5 p.m. All right, just so I don't ruin my weekend too badly, and your weekends as well. The reason why I have cutoffs for questions, usually 2 or 3 days in advance, is I find the questions get really bad before the exam. People are panicking, and they're questions born of fear and concern and not reason. So questions by Friday by 5 p.m. I think that's fair, and I'll do my best to get you an answer by the weekend. Also, sometimes people send me a question the morning of, like I can't get to it. Presley asked for the policy questions being the same year as the previous question. I don't understand your question. Oh, is it set in the same year? Yeah, no, everything's set in the 1860s, so that's where you're stuck. No matter how recent I say the question is, you're stuck in the 1860s. Okay, Lauren, did you have a question?
Actually, it was more back to number 5.
Sure.
You can talk quickly. So, talking about the Sedition Act, I understand that. Could you have also talked about the Declaration of Independence and the importance of?
That's a good, excellent. You should.
You can talk about that. Okay.
Yeah.
Yeah,
I mean, the reason why we have a constitution in large part is because of the experience of the Brits. I think it's fair game.
Right. Okay. And then in terms of your due date for questions, would you be willing to look at a midterm, or is it too late?
At this juncture, no. I mean, we have plenty of time for that, but I can't now. I appreciate the offer, but I put the midterm out over spring break, so that was the time to do that.
Understood. Thank you.
Okay, Mike, go ahead.
The American theory, British theory of free speech, how far back do those go? Like, do those go all the way back to the founding, or are those more recent?
I think we talk about it in the context of Madison's understanding. If Madison wrote about it, it's fair game.
That's what I thought. Okay, thank you.
Yeah, so there wasn't nothing new. All right, I have 2:20. Let me start the minute poll. I'll tell the story in a minute, but for those of you who have to leave, thank you so much. It was a fun semester. I enjoyed having you all. I hope in the fall or in the spring you can come by and say hi. Many of you I know from at least 3 or 4 weeks of class, but some of you have not met, so hopefully we can meet you also. Thank you all so much. And you're welcome to go, or you can stay around. So here's the Cuomo story. For the last 7 years or so, I've been working on a case involving 3D printed gun litigation. You may have heard of Defense Distributed in Austin. They're always in the news. They developed the technology to share files that can be used to 3D print a gun. And I'm one of their attorneys for many years. First and Second Amendment combined, my kind of case. In 2018, we reached a point where our client put some of these files on the internet to download these files. And to summarize things, we were sued across the country very quickly. And one of our lead attorneys sort of dropped out, and I became the lead attorney overnight. And I had to argue 4 TROs in 5 days, which was pretty intense, in different courts too. We had to argue in Austin, in New Jersey, in Philadelphia, and in Seattle, basically across the country, one after the other. I won the first 3 cases. I got the TROs denied the first 3 cases, which, I felt pretty good about it. Then the 4th one, the judge in Seattle entered a nationwide injunction against us, which really sucked if you're in the losing end, because no matter how many cases you win, if you lose a nationwide injunction, your case is basically over. So I had been arguing all day. I was exhausted, and this judge in Seattle just entered this nationwide injunction, and we were sued by like 20-something states. Basically, every Democratic Attorney General versus Josh was the name of the game. And then after everything, and I got my butt handed to me by this judge, I sort of said, okay, fine, the day's over. I called my client. He took on the website, fine. About maybe an hour later, my phone rings, and it's a restricted phone number. That's a block. Oh, God, what now? Am I getting sued again? And I pick it up, and, it's like, hello? It's like, this is Governor Cuomo. I'm like, oh, no way. He's like, yeah, this is Governor Cuomo. Like, what are you calling me for? And he's like, you tell your guy to take his files off the internet. And I told him, like, you already won, right? Your attorney general sued me and got a nationwide injunction against me. And he says, well, she doesn't work for me. I'm like, okay, I know where this is coming from. He wanted credit, right? He wanted to be the guy that took it down, not his attorney general. And he's like, in my state, the attorney general doesn't work for me. I don't appoint her. I'm like, yeah, I know how that works. I'm from New York. And then he's like, well, you tell your guy to take his files down. I'm like, you already won. And then I said, tell your attorney, send me a letter, and I'll look at it. And of course, they never sent me a letter. But then it sort of keeps going. And he said, so you're from New York? I'm like, yeah. He's like, so do you miss New York? And I said, no, not really. I like Texas. It's true. I don't miss New York. I miss my parents deeply. I'm going to finally get on a plane this summer to New York. I've been there more than a year. They've been here, but I haven't been there. So I said, but I miss my parents. And then it gets surreal. He's like, so your parents are in New York? I'm like, yeah, they're in New York. He's like, well, are they going to vote for me? Because this was in 2018, a few months before the election. And I'm like, oh, this guy's got to be kidding me. I'm like, yeah, they're loyal Democrats. He's like, good. And he's like, how did a guy like you wind up in Texas? I'm like, well, I like it here. And we're talking for 15 minutes. He's just shooting the breeze. He called to threaten me, and now we're just chatting. And at the very end, I'll never forget, Governor, today's my parents' anniversary. I have to call them soon. He's like, you know what? You tell your parents Governor Cuomo wishes them a happy anniversary. I'm like, okay, thank you, Governor. And then we hung up, and I called my parents. And they were all happy. So, when I see these reports of Cuomo threatening people, I've been there. He threatened me. And then like 5 minutes later, he was trying to get my vote, or at least my parents' vote. And they voted for him, even though they, that's loyalty when, the governor sues your son and you still vote for him. That's I'm just kidding. It's all good. Usually my parents visit my class. They couldn't the past year and a half, but they will be here in the fall. Anyway, that's politics in a nutshell. Governor Cuomo threatened me, then asked my parents to vote for me in like 5 minutes. I never got a letter from him, never heard from him ever again. He probably forgot about it, but there we go. So First and Second Amendment in one. That's why I like the case. See, it's a long story. I couldn't do it in 2 minutes. It takes a few minutes to set up. Okay. Other questions for the 50 of you who remained and didn't leave to hear me go? Anything else? All right. This was fun, guys. I appreciate the semester. Hope to see you all in the fall. Good luck for exams, and we'll be in touch. Thank you.
Thanks, Professor.
Thank you so much.
Thank you.
Thank you so much.